Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. Today I want to talk about the creation of potential conflicts of interest. Lawyers are supposed to make sure that confidential information that's given to them by one client isn't used against another potential client. So that if the wife calls up a lawyer and tells him all this confidential stuff but doesn't hire him, the other side, the husband, can't go and hire that lawyer and benefit from all that confidential information, because that would be an appearance of impropriety. It would be a conflict of interest. It's the kind of relationship that the parties should stay away from. And that's really done for the purpose of preserving the fairness. In other words, you're supposed to be able to confide in a lawyer, but if you've got to worry that if you confide in them, it's going to be shared with the other side, you're not going to want to confide in your lawyer. Unfortunately, though, the public, perhaps it's because of the internet, or perhaps it's because of other information that they get, the public knows that lawyers who have confidential information can only represent one side, can't represent the other. We have seen an epidemic occur, it's going on all over the place, where people, in order to make sure that their ex can't get a lawyer from a preeminent firm, will go to the preeminent firms in the area within a certain amount of mile radius and do consultations with all of them. And in doing so, when the other party calls and says, hey, I want a lawyer, they say, oh, sorry, your name is Mrs. Jones. We've already spoken to your husband, Mr. Jones, and therefore we can't offer you representation. And the funny thing about that is, the one who made those calls, the Mr. Jones in my exam, he never intended to hire any of those lawyers. All he intended to do was spoil the pool so that his ex, soon-to-be, couldn't pick up one of those lawyers. So in order to avoid that, in order for the lawyers to avoid being abused by people who had never intended to hire them anyway, but yet are interfering with that level of business, certain people have done certain things to try and weed that out. They ask a lot of questions. They try to, on intake, when people call in, to ask them, have you ever called before? Have you spoken with any lawyers and all that? At our firm, we make it very clear to everybody when we do intakes that we're not taking any specific confidential information. If you have specific information that you want to be held in strict confidence, you have to first establish the attorney-client relationship by signing a retainer agreement and hiring the firm. Then, of course, everything is confidential. We make sure that in that first telephone call or that first conference that we have, that is before we're hired, to tell them, don't tell me anything that's in confidence. Don't tell me anything that is a secret, because anything that's a secret that you want in confidence, that should be preserved for the actual attorney-client relationship. And if you do it that way, you avoid the person being able to go firm to firm to firm and tainting all the firms for use of the other person. Now, we do this. It would be great if other firms had the wisdom to catch on to do this also. Some do, some don't. But hopefully this will avoid a situation where somebody manipulates the available representation pool. If you have any questions about your case, of course, reach out and we'll be glad to help you out.